Amber Manley versus Ashley Furniture. Mr. Klopfenstein is here and Amber Manley is here. So let's address this one. This case has got a long, unpleasant history. Miss Manley, would you have a seat over here? And Mr. Klopfenstein, would you have a seat over here?
When a lawsuit is filed, the clock starts ticking, and ignoring that clock can destroy your case before it even begins. Ashley Furniture thought silence was harmless, but the court saw it as defiance. Today's hearing shows exactly how fast a missing defendant can lose control of everything. Let's step into a courtroom where one mistake turned into a full-blown judgment.
I hope this case was done, but it isn't. This is file 242120. This involved a long testimonial case about some lawn furniture that Miss Manley bought from Ashley Furniture. We had a hearing which was set for March 10th, and nobody appeared on behalf of Ashley Furniture, and a default judgment entered at that time on behalf of Miss Manley in the amount of $1,735.42. In an attempt to collect on that, then I got a motion from you can have it. One of our cases has been dismissed. Then there was a motion to set aside the default, which I declined to grant. And so the motion, the judgment stands. And that was on April. In order to set aside a default, in fact, it's not even exactly clear whether you can even do it in small claims court, but I had a hearing. You have to show a legitimate defense and good cause for not appearing. I didn't find any good cause for not appearing. So the plaintiff then did a subpoena to discover the ability to pay on this debt, and nobody appeared from Ashley Furniture for that. So we set a show cause hearing regarding this. So Mr. Klopfenstein, thank you for being here. Miss Manley, you as well. Mr. Klopfenstein, will you raise your right hand? You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
I do.
You so far have got about $10 zillion worth of bad publicity out of this case. I found on her behalf by default in the amount of $1,669.17, $62.28 for a total of $1,735.42. She wanted to add some other items, but they weren't part of the original complaint, so I wouldn't allow them to be added. You moved to set it aside. I denied the motion to set it aside. She did a subpoena to collect. She wants her money. You may feel that she was already made whole. She got the furniture returned plus other stuff, but this judgment entered by default. So the ship has sailed. You owe that amount of money. Do you have the ability to pay that?
Your Honor, we did switch out the piece for her.
I got it. I got it.
Okay. Okay.
But then the lawsuit was still going. You didn't show up. So a default entered on her behalf. You had a motion to set aside the defense. The default. You may have had a meritorious defense, but you didn't show up for the hearing. And I had a hearing to find out why, and there wasn't good cause other than I guess they forgot. So, yes.
Your Honor, I was out of the country. I did not know about it, but we thought it was made whole by exchanging the piece.
I understand.
We thought it was made whole.
It wasn't. And I didn't like entering the default. I thought she got paid twice. I thought she got made whole plus she got $1,600.
Yeah.
But you got notice. There was a hearing. She was here. Nobody showed up and a default entered. So yes, you got arguably double dipped, but you owe this money because you didn't show up. So, we're not gonna revisit your defense. You weren't here to raise your defense. Then I had a hearing to set aside the default, which I'm not even sure I can do in small claims court. And I didn't set it aside. Now she wants her money. And then there was a subpoena and you didn't show up for that. I'm trying to determine when that was. That was, we did move it.
You moved it, yeah. It is.
You were to be here on 9/29. Oh, yeah, we moved it to this date.
Yes.
Not sure why this is a show cause. Just failed to pay, failed to appear for the motion, but I don't remember a subpoena for discovery. I'm not sure. It's an order to show cause why you should not be in contempt, but I don't see that you missed anything to be in contempt.
I'm sorry.
Yes,
I had to pay the St. Joe County of Mishawaka to have Ashley's furniture served.
I'm trying to figure out what date that was. I'm looking and it's not in the paper file in front of me.
And then he didn't show up.
Yes, I'm trying to determine what date that was.
I filed, oh wait, let me make sure.
Here's the subpoena. Subpoena was for him to appear on August 11th. And he did not appear. That's why you're in contempt. You got served the problem is you're too busy. You don't show up for stuff. So
I'm also out of Fort Wayne, not, we have a store in Mishawaka, but
yes,
maybe that's what was served. I am out of Fort Wayne.
let's see where the proof of service is. Picked up the plaintiff to have personally served on the defendant. Service of subpoena. It was served allegedly by a sheriff's deputy for St. Joseph County, which would be South Bend. Cost her $88 additional. Well, they served it on Ashley Furniture, Great Road, Mishawaka, Indiana is where they served it, which is St. Joe County. So they served the business, not you. All right, at any rate, the judgment stands, whether it's fair or unfair, it does. So she wants, it was for a discovery hearing, for you to come here, for me to put you under oath so she could ask questions to you about your ability to pay on this debt. Now, you're not an attorney, and I don't hold you to that standard, and neither is she. We're in small claims court, and the rules are more relaxed, but they still are the rules of civil procedure. The hearing you failed to appear for on March 10th, I placed Ms. Manley under oath on March 10th and asked her some questions. And she still wanted her $1,699, failed to appear for this hearing, which was noticed for that day. Then I had a second hearing regarding the request to set the default aside, and I denied it. So you owe her $1,735.42. And she's here because she wants her money, plus 88 additional dollars for the additional service.
Your Honor, may I speak?
Yes.
Yeah, the piece that the court had ordered us to replace, we did. We replaced it and everything.
I understand all that. You missed the hearing. So you want to raise your defense that you failed to show up for and raise the defense. So I was compelled to issue a default judgment. So you dropped the ball to the extent that it's cost you $1,735.42. I understand that you have some defenses you wish to raise. And I didn't enjoy entering this default judgment on March 10th, but you didn't show up. And then I had a hearing regarding why you didn't show up, and I didn't find good cause to find out why you didn't show up. So the ship sailed. You owe this money. Do you want to pay it, or do you want to get another $10,000 worth of bad publicity? $1,735.42 plus 88.
Do I not get the furniture back, Your Honor?
No.
So she gets the furniture?
Yes, she gets a double dip because of your failure to appear for the hearing, which is what stopped. You prevailed. I took testimony. She was unhappy with what she got. She wanted to sue for even more. Ms. Manley, do you have any other expenses other than the $88 service fee?
Just my loss of wages for all of my work missed.
That's not recoverable in
Then
small
the
claims.
notes-
Was there a filing fee for the subpoena or anything?
Just what I had on the paper already.
All right. $1,823.42. What was scheduled was a discovery hearing. And then her to discover your ability to pay on the debt. You're here, she's here, you're under oath. I don't find that you're in contempt for failing to appear for that subpoena. The officer just subpoenaed your store. And then I don't know what they did with it, put it in a desk drawer or something, but they didn't give it to you and nobody showed up. So I'll take you at face value that you didn't know about that hearing. Then I did this, that you specifically had to be here so we could all be in the same place at the same time. But in order for her to do that hearing, she paid an additional $88 to have a South Bend, St. Joe County, Indiana deputy serve you. So that's where we are. It's difficult to execute on an idle state judgment. If this were in Michigan, she could seize your assets. She could come with a court order with a deputy and take money out of your till, I suppose. I don't think that's ever been done, but seize tools, trucks, that sort of thing to auction to pay the debt. This has been, you've been here 6 times. I don't know. You've both been here repeatedly. I've spent, I don't know, 20 hours on this case regarding this furniture.
This is the first time I've ever been here physically.
Okay.
I was at, before it was Zoom.
All right. Well, that's why I wanted to get everybody here. So the question is, are you willing to pay $1,824?
Again, Your Honor, she keeps the furniture. I pay her back for the furniture.
Yes.
And she's able to keep it. And
Yes. I don't enjoy it. You didn't show up for the hearing. I took testimony. A default entered. She's still unhappy. She wants more than this. So I can't be any more clear. We had a hearing to set aside the default and I denied it. Yes, she gets the furniture and the money. So how does it, whether it's fair or not, that's how this came, because you didn't show up. So if you're not going to pay her the money, she can get an order to seize your property and fight it out that way. But
may I ask another question? Your
yes,
Honor?
sir.
And talking to my local attorney, he thought the jurisdiction would be in St. Joe County.
Jurisdictions at both ends.
Where you buy it? Because we have no stores in.
Yes,
Yeah.
where she is and where you are. And it's a small claims case. The furniture was delivered to her in St. Joe County, Michigan.
Or picked up. I believe it was picked up.
And so,
A repair was
A
sent to
repair.
my house.
But the furniture was initially picked up in St. Joe County and at the store at the St. Joe County. I'm not an attorney. I don't understand.
I
a lot of the
understand,
things, and-
but yes,
And our representative from Fort Wayne said he could not represent us in Michigan.
well, and you can't have an attorney in small
Yeah,
claims
that's
court.
right. He
You
also
can
said-
remove it to the general division of the court she would have had a harder time presenting it following the rules of procedure. All I want to know is, are you going to pay her the money or not? If you're not, then I encourage you to then get an order to seize property. You've got so much bad publicity about this, then it should really have just been resolved a long time ago. She's very diligent.
With Your Honor, I thought it was resolved, so I apologize for that, and as far as paying, yeah, if you tell me where to send it, I will get it sent out.
All right, very good. Plaintiff will pay within 21 days. Her address is on the complaint and on the judgment. We'll give you a copy of that.
So I sent it to that address.
You sent it to her, not to the court, to the Youngs Prairie Road address, Constantine, 49042. That's still correct?
Yes, Your Honor.
Yes, I understand that you feel this was unfair. She also feels it's unfair, so man, there's enough unfair to go around. I didn't like her getting the furniture and the money. It seemed unfair to me too. But I issued that order, and I'm not gonna say it for the 5th time. You didn't show up. So I'll have the bailiff take you out to the court office. The clerks will make sure we have the right address, and you should send 1,824.42 to Amber Manley at her Youngs Prairie Road address. All right, this was a very unpleasant experience for both of you, and for that I'm sorry, but I'd like this matter to be concluded. All right, 1,824.42 within 21 days.
Thank you, Your
All
Honor.
right, thank you. All right, thank you for coming all the way up here for this unpleasant experience. All right, you're both good to go.
And there it is, the price of not answering the court. No drama, no debate, just a simple truth. If you don't show up, the judgment will. Ashley Furniture walked in hoping for a reset, but walked out with a bill stamped by the judge himself. In the world of justice, deadlines aren't suggestions, they are destiny.